Hi, welcome to the podcast on the court system for legal research, writing, and analysis. In the United States, we have two parallel court systems. We have the federal system and then the state system. In the federal system, the courts will hear disputes or violations of the statutes that have been enacted by Congress. Most of the cases in the federal courts involve federal laws, and the courts can also hear patent or copyright issues. On the state side, the courts will hear disputes about particular state statutes or state laws, burglary being one of those. Some other ones are family law, contractual disputes, or personal injury cases. Now, as you can see from this diagram, both the federal and the state system, the disputes would begin in the trial court or the district court, would then go up to the Court of Appeals or the intermediate appellate court, and then finally to the highest court in each jurisdiction. For the United States, it would be the United States Supreme Court. In the state system, it would be the state Supreme Court. As you know, the United States Supreme Court is the highest court in the federal court system. It is comprised of 9 justices, 1 Chief Justice, and 8 Associate Justices. The court usually is a reviewing court, so it reviews lower court decisions. But in a rare case, it may be a court of first jurisdiction. For example, if 2 states have a boundary dispute, they may appeal directly to the Supreme Court. It's still discretionary, though. You have no automatic right to appeal to the Supreme Court. If you seek to appeal, you would file a petition of writ of certiorari, which is a request to review your case. If you are denied cert, it's the end of the road. Typically, 10,000 petitions are filed each year, and the Supreme Court hears argument and grants cert on about 75 to 80 cases. Now, from this diagram, you can see that there are several feeder courts that feed into the United States Supreme Court. And these are called the U.S. Court of Appeals. And the country is divided into different circuits or different areas. Each circuit has its own court. A circuit can be made up of either one state or several states. There are 13 different circuits in the United States. 1 through 11 we just call by their names. First Circuit, Second Circuit, Third Circuit, and they're each assigned a number. There is also a circuit called the D.C. Circuit, which will hear appeals within the D.C. area. And in addition, there's another circuit called the Federal Circuit. Now, usually the 11 circuits review decisions based on geographical location. For instance, if the case occurred within its boundaries, it would hear the appeal. But in this Federal Circuit, it hears cases based on subject matter. So, for instance, patent, trademark, international trade or veterans affairs cases would go to the Federal Circuit. In essence, then, a case could be heard either by, let's say if it happened in California and it went up to an appellate court, it could be heard by the Ninth Circuit Court of Appeals or the Federal Circuit if it dealt with one of those particular subject matter issues. Okay, on this map you can see the different circuits in the United States. You can see that there are various sizes. So, for example, the Ninth Circuit out in the West Coast, look at how many states feed into that circuit, as opposed to, let's say, the Second Circuit on the East Coast, including New York. A smaller number of states feed into that circuit. So you can see from this chart that the circuit courts are fed into from different district courts. Each state has at least one district court, and many states have more than one. So here is a map that shows you the different districts within each state. You can see that Washington, for example, has 2 districts, a Western District and an Eastern District, and yet Oregon has only 1 district, the District of Oregon. Similarly, in Michigan, close to home, we've got 2 districts, the Western District of Michigan and the Eastern District. This chart shows the appellate process for a case filed in Michigan. If the case was heard in the United States District Court for the Western District of Michigan, and a party feels that the court made a mistake, it could appeal to the next level, which would be the United States Court of Appeals for the 6th Circuit. If a party was not satisfied with that outcome, it could file a writ of cert to be heard by the United States Supreme Court. Remember the terminology we use. When an appellate court hears a lower court's decision, it can either affirm the decision, which means it agrees with the lower court, or it can reverse the decision, which means that it disagrees with the lower court's holding. Why is this discussion of jurisdiction so important? According to the doctrine of stare decisis, courts in the United States are obliged to respect the precedent established by prior decisions. So the court follows the precedent of prior cases within it. So in other words, if a case was filed with the U.S. District Court for the Western District of Michigan, that court is bound to follow the precedent from the Sixth Circuit because Michigan is part of the Sixth Circuit. So all those decisions that came before it in the Sixth Circuit are binding authority. On the other hand, other circuit decisions from the Fourth Circuit or from the Ninth Circuit are persuasive authority. The court can choose to follow it, but is not obligated to do so.